Kauwaka rā te rā tapu taupua I ho te rangi tī hore te rangi waru hia. Kia mātau ki te atāni ho mai nei he tohu mo tōna matua I te rangi. Tā taitia rā te pai a ki rina rā kia matariki ki au tahi kia takurua. Ki nā whetū tapu o te rangi, ringi hia I te kete ko te I kanui o rani kānaro ki rina rā, ti hei mauri ora. Kei nāhi nā tore o te rangi tauihi. Koutou ko tau mai nei ki te ururua o te herena waka. Ko u mai nei ki roto I te whare tā wharau nei a tātou I tēnei pō, tēnā koutou katoa. Tēnei, te reo whakatau o te herena waka, e whakatau nei a koutou I tēnei pō, nō reira haere mai, haere mai, haere mai. Kai tā rei nā kupu kōrero I te pō nei, James, tēnei te mihi ake ki a koe, e whakawātea nei a koe, ki te kauhau I nā kōrero kei mua I tō aroaro, ka whakairotia I tēnei pō, tēnei te mihi ake ki a koe. Ka mihi ake anō hoki ki te whānau Borrin koutou. Nā kai pupuri I te āhuatana, o nā kura huna, o nā kura māhorahora, tō koutou whānau, e pāororotia nei I roto I nā whare e tūtū nei, I roto I te kauhana nui. Nō reira tēnei, ka mihi ake, tai noa ki a koutou te rāhui, te kāhui. Tā, koutou e noho mai nei I roto I te kauhana nui, I te kauhana roa, e puta ai. Nā mahi I oti a koutou te pai ao, ki te ao mārama, tēnei te mihi ake ki a koutou. E tio, e paite ki te aki I a koe, I hui mātau I te taha o nā tohuna, I nā rā, kua tata tonu te whakatupera anō, I tō tāua marae. Hoi anō, ka puta I te ruanuku, e tahi kōrero, I puta rā tana wairua whakatoi. Ka nohoa ia ki te rawe ki a pakake, ka puta I a iau e tahi kōrero, mo nā whakataetai wāne nui I a kōrua. Nō reira, paite ki te aki I a koe. Nō reira, kei te huna e noho mai nei I roto I tō tātena whare I tēnei pō. Tēnei te mihi ake ki a koutou, kei nā mana nui. Koutou, kei nā manu taiko, tēnei, te tuku I nā kupu whakamiha ki a koutou I tēnei pō, I rina I te āhuatana o te reo, whakatau o te hina waka ki a koutou. Nō reira tēnei, ka whakairi ake I nā kōrero. Ko rātau mā, ko ariro atu nei. I te rua kōhā matariki ki a rātau, tātau e takatū nei te mata o te whenua. Huri noa, tēnā koutou, tēnā koutou, tēnā tātou katoa. E papa wai ari, tāku nei mahi he tū, kuroi mata. I aue, ka mate ahau, e hine hoki mai rā, e hine hoki mai rā.
Nau mai, haere mai, tēnā koutou, tēnā koutou. Tēnā koutou katoa, inga rau, ina mana, inga waka. Tēnā koutou, tēnā koutou, tēnā koutou katoa. So for those who don't know me, my name is Nick Smith and I'm the Vice-Chancellor of Te Herenga Waka, Victoria University of Wellington. And one of the central roles of any Vice-Chancellor is to live vicariously through the achievements of not only the faculty and the students, but the collective alumni. And having just watched the health and safety video, we won't be protected from a tsunami because we're on not such physical high ground, but I look at the collective talent and history assembled here, and I think there's no doubt that on ethical, intellectual, and dare I say it, legal ground, we will be well protected for tonight. In that protection, it's my enormous privilege to welcome you all this evening and extend a particularly warm welcome to our guest of honour, the faculty's 2024 Borrin Fellow, Professor Jamie Lee, who will be delivering tonight's lecture. I first met Jamie a few days ago in a very different context when he was the ring-in for the legal team's university quiz night. He's since admitted to me that he is an ex-member of the Balliol College University of Oxford University Challenge. And with that collective talent, they finished a commendable, if not extraordinary, third place. But in more serious notes, Professor Dickson is also on another form of university which I've been part of, King's College London, where he is at the Dickson Poon School of Law. He's a highly respected teacher, academic, researcher and editor, and his work has been cited in courts and law reform agencies in numerous common law jurisdictions. He's the author of one of the leading English textbooks on trusts, the Hanbury and Martin, Modern Equity, and is highly regarded in the common law world as a promoter of the academic enterprise of law. As well as many other significant contributions to legal scholarship and education, Jamie is renowned for his tireless work supporting junior scholars and is a very active X feed, or Twitter for those who are a little older, filled with offers to assist those considering academic careers or seeking mentorship. And having read this, I will take note and look for that and opportunities for myself in the future. I know that I speak not only for myself, but for the whole university when we say how honoured we are to have him here speaking tonight. Before we begin tonight's lecture, I want to take a moment to recognise Ian Borrin's partner, Jenny George, who is not with us tonight, but her family are. My colleagues in the law school tell me that one of the delights of this event is to remember Ian, but also catch up with you. I'd also like to acknowledge Justice David Goddard, Ian's cousin. Ian was a proud Vic graduate. He practiced law in Wellington before being appointed to the District Court, the Family Court, and later in his career, the Police Complaints Authority. He was a cherished friend of the law school, not only because of his generous donations to the Law Review and the endowment that supports this lecture, but also because he was a kind and gentle man, and his encouragement for the school continued to improve and excel even today. His generosity has had a lasting impact, including, for instance, last month when the faculty co-hosted a symposium on corporate law with the University of Richmond in the United States. This event was only made possible because of Ian's generosity. In the 8 years since his passing, the late Justice Borrin, this annual lecture remains a significant and cherished tradition in the Faculty of Law. The idea of a fellowship which emerged from discussions with Ian about how he might support us even further reflects his commitment to enriching our academic environment. His enthusiasm, which has been adopted with this idea of inviting an overseas scholar to share their expertise and participate in the faculty's academic life, is embodied today with Jamie, who is exactly the kind of person that Ian would have had in mind. Please join me in giving a warm welcome to Professor Jamie Lee.
Tēnā koutou katoa. Me mihi timata aho ki a George Borrin, me tōna whānau nā ka tako ta toko e tēnā ka popa, nāna ta pama me te mana o te kopapa nei, ngā mihi nui a ka koutou katoa. No Ingarangi me Airani o ka tu puna a, I whānau me aho e Chatham Kent, he hapuri ke te petonga Ingarangi. He oi e tupi ake aho ke te taha o Inga Awa Thames ki Oxfordshire, me te taha o ta Awa Lagan ki Belfast, me te taha anō Onga Awa Maha o Manchester. E noho ana aho e neani ke ranana he aronge e te turi Ingarangi o he ke King's College London ke reira. Ko James Lee toko ingawa hoe ka pei koto ke te kairanga e hao me Jamie. Tēnā kato, tēnā koto, tēnā ra ka toto katoa. I'm very grateful to Kelly Mitchell of the faculty for her assistance. All of that is true. And following the safety video, just before I promised to begin in a moment, I just wanted to say kia ora. My name is Jamie. Thank you. Welcome here for my lecture. I am excited. So thank you very much. It is so many different abstract nouns, an honour, a privilege, a delight for me to be here. I'm very grateful to Borrin, the Borrin Fellowship and the George family for their support and kindness and generosity. Very grateful to the Vice-Chancellor for his very kind words, to the Dean, to Professor Maclay for facilitating this. Very grateful for everybody coming here when you did not have to. So what I want to do today is talk about Once Upon a Time in the Common Law, institutional narratives and legal change. And what I would like to do, if the slides will work, is to reflect on why it might be helpful to talk about stories. And I want to be clear that I'm not being pejorative when I say that judges tell stories. All of us do. And the question is whether thinking about the law, about cases, about courts in terms of narratives helps or not. When there are questions at the end, please say that it did help. And I will be comparing the New Zealand Supreme Court and the United Kingdom Supreme Court for reasons which I'll say in a moment. And I've picked two pairs of cases, one in the area of charity law and another in the area of really cool, interesting things that are happening in the law of tort, which is suing people for stuff. Now, in the written version of this lecture, there's an awful lot of scholarship that I've read, so you don't have to, on narratives. I'm going to keep it light because it's a Thursday, but there is an awful lot of scholarship about why narrative does matter, and I don't want to give the impression that I've not read it. And the value, I think, is that it can potentially, thinking in terms of the different narratives that the law relies upon, that judges rely upon, that institutions rely upon, can help us to have a deeper understanding, or at least a different understanding. And I'm conscious we have a mixed audience of members of the general public, students, judges, lawyers, even some academics, and we all have different perspectives to bring to it. And then I'll conclude with one or two thoughts about maybe where we go from here. So, why does it help to talk about origin stories, the institutional narratives? Well, each case that we read, or have to read, is a story in and of itself. It matters to the parties before the court, it matters to the judges deciding it, and it also matters for the impact it has going forward, for how the law develops in the future. But I also want to highlight that each case plays its part in the institutional narrative of the court that decides it. And one of my claims here is that the way in which courts, particularly final courts of appeal, develop their narratives enhances their role in the Constitution, enhances their role as institutional actors, particularly in times of disruption and uncertainty. This is a photo of the Backbencher pub. I noticed that it has a sign, the House with no peers, which is good for two reasons. One, New Zealand has a unicameral legislature, but also the United Kingdom Supreme Court was born out of the House of Lords, so it is, in its own way, a house with no peers, but this pub serves better beer. So, why have I picked New Zealand's Supreme Court and the United Kingdom's Supreme Court? Well, partly it was kind of the reason why Jeff invited me. But also, there are some similarities that I think are of interest. First, they both have amazing buildings that I take photos of. And both of them are relatively new courts in their current guise. And so the judges, the whole institution, has been creating and curating the court as an institution. Because, happy birthday to the New Zealand Supreme Court, it's 20 years this year since it came into being. And it's 15 years since the United Kingdom Supreme Court was inaugurated or instituted. So both of those are opportunities to take stock. But those are not the only reasons. In addition, New Zealand and the United Kingdom operate without written constitutions. And both of these Supreme Courts are full-service courts. Right? They don't only focus on the cool constitutional cases. Right? They deal with cases involving criminal law, private law, cases that matter to everyday people. And I think there is something interesting about focusing on these grand questions about institutional narrative, not in the constitutional mythology context, but in the everyday law that matters in law offices up and down the country. So a little bit of statute. As the Chief Justice has noted, unfortunately, the purpose of the act that created the Supreme Court has been repealed, but the point still stands. The aim in abolishing appeals to the Privy Council and creating a final court of appeal for New Zealand in 2003 was to establish within New Zealand a new final court of appeal, to recognise it as an independent nation with its own history and traditions, and to enable important legal matters, including legal matters relating to the Treaty of Waitangi, to be resolved with an understanding of New Zealand conditions, history and traditions. So this idea of the institutional narrative of the court is baked into its origin. It's not just the substantive law that it develops, it's the people and the institution as a whole. A further reason for comparing the United Kingdom and New Zealand is that there are some differences in how fulsome statutes can be. So Section 23 of the Constitutional Reform Act, there is to be a Supreme Court of the United Kingdom. That jussive subjunctive took 4 years to happen. There are some other provisions. So, as I say, there is a lot of scholarship, a lot of talk, particularly in the American context, around the value of stories, narratives, myths in the constitutional context. And several of the justices of the New Zealand Supreme Court have written on these themes. It might be invidious to talk about it, but I'm going to anyway within the room. So, this idea of a distinctive editorial New Zealand hue to public law, to what extent can we see that permeating through all of the common law of New Zealand? And when is it just sometimes judges taking a different view, regardless of what nationality they are, on what the legal principles should be? In addition, Justice Williams has spoken about the inherent adaptability and flexibility of the common law. Now, this in and of itself is a narrative. And what I want to show in the cases that we'll be talking about is that narratives around how the law develops feed into the perception of the court, but also they frame how lawyers should bring cases to the court, how you should frame the arguments in question. Now, as I mentioned, there's loads of scholarship on narrative. I want to be very clear, I'm not the first person to use the word. And this is just an indication of the sorts of narratives that might be employed when we talk about it. So at one level, just what happened in the case. The factual narrative, which by the time cases get to the Supreme Court, they're not often in issue. But when it's in a trial, there are competing factual narratives of what happened, and the judge has to resolve it. And the way in which the judge resolves the factual controversy then informs the legal resolution of the dispute. There are also then argumentative narratives. Who's right? How do we frame the sales pitch to the courts to try and persuade them to listen? How do we situate that in the context of the development of precedent? The common law system that we pride ourselves on in both of our jurisdictions is grounded in precedent, but each case is itself a story. But then we need to tell a story about the arc of legal development, and we can have different perspectives on that. Then we might say there's a kind of intellectual perspective. What theory is in play here? How do we fit our theory, our narrative at that level to the narrative of the case before us? I think cultural narratives, particularly a lot of scholarship from America in sort of 70s to 90s in particular, looked at minority voices being able to tell their own stories, whether ethnography or individual testimony, and how that should shape understanding of the law. Temporal questions, the role of time in narratives, where have we come from, where are we now, and where are we going? And then individual narratives, because another common feature amongst Supreme Courts that New Zealand and the UK share that not all courts do, is that every judge can give their own judgment if they want to. So individual judges, not just the lawyers arguing about it, individual judges might have a different story to tell on the facts of an individual case. And then, as I've mentioned, the institutional perspective. What I want to focus on in this lecture are a little bit of the factual narrative, a lot about the developmental narrative of the law, and then also the institutional one. Now, just a couple of caveats. Hannah and Meisberg, Hannah's at Auckland Law School, have edited a really interesting collection on narrative. And they've said, helpfully, the notion that law involves or depends on narrative has become downright intuitive, even cliche, to both those inside and outside the legal system. So the scholarly challenge, for me today, is to get past the vague performative utterances about the intimacy of the law and narrative and to break down the many varieties and contradictions in that relationship. Feel free to raise your hand if you think I'm being cliched or performative at any point. So one caveat is that I'm standing on the shoulders of many, many narrative giants here when talking about this. Secondly, when we talk about stories, and I want to link this to the common law imagination, there can be a tendency to slip into saying, this is all fiction, it's all narratives are the same. Right? I am not claiming that the way in which narratives operate in law is the same as narratives in literature necessarily, only that we can learn from some parallels. And if there was any doubt, one of my favourite authors, it is genuinely one of my favourite authors, I'm not just being pretentious, Murakami wrote this great book about novelist as a vocation, his thoughts about writing. And he said this: neatly put together arguments and value judgments aren't much use for those of us who write fiction. More often than not, they impede us by blocking the natural flow of the story. Now, hopefully, apart from in this lecture, for lawyers, the opposite is true, right? We do want neatly put together arguments, and we can't avoid the value judgments. So I'm not claiming that all law is fiction or that law is literature necessarily. What I'm saying is thinking about narrative is potentially helpful. Equally, Murakami also said, writing novels is, to my way of thinking, basically a very uncool enterprise. I see hardly anything chic or stylish about it. Novelists sit cloistered in their rooms, intently fiddling with words, batting around one possibility after another. They may scratch their heads an entire day to improve the quality of a single line by a tiny bit. No one applauds or says well done or pats them on the back. No lawyer, judge, or academic can relate to that. I mentioned that we have a mixed audience here, and the audience of judgments of the work of the court is also a mixed one. This is Arsenal's stadium, because they're the best. And when we're thinking about narrative, we do need to think about to whom are they addressed. And particularly, it's not just the imagination of the individual judge, it's the imagination of the reader that you're trying to capture when persuading. One of my predecessors as Borrin Fellow, Professor Koskiniemi, made this point. Law is not only about the truth of this or that matter, but about persuading audiences to act in some particular way. Imagination is needed to find the winning justification, to hit at the right vocabulary, and we must travel widely in our imagination in order to find a good argument. So, who are the audiences? Loads of people, right? Everyone in this room. The parties for the case, the lawyers for the parties, but also lawyers more generally, judges up and down the jurisdiction, judges in other jurisdictions, fellow judges on courts, judges in higher courts, students, academics, politicians, law reformers, other institutions, journalists, and the general public at least. What we take away from this list is that it's really hard to be a judge. You have to frame a judgment that satisfies all of these audiences. But I've led with the parties because ensuring that people feel that they've been heard matters. And so ensuring that a narrative speaks to the people who are before the court, and particularly in a couple of the cases that I'm going to talk about shortly, we must never lose sight of the fact that there are real people at the heart of our narratives when we're talking about law, which isn't the case for fiction. So as I mentioned, we need to think about whose stories are being told. Are there other ways for voices to be heard? And I don't want to diminish the contribution of that scholarship when I say that it's not my focus today. So before we come to the cases, just a final point from another leading scholar on the legal imagination, Professor Max Delmar from Queen Mary University of London. Courts attempt to maintain some narrative coherence in areas of the law, but this commitment to narrative coherence is by no means a sign of conservatism or a lack of imagination. On the contrary, the use of narrative in this backward-looking sense is a very imaginative endeavour. The continent of stories the law tells is constantly changing shape. This is a kind of uncertainty that the law cannot live without and is all the better for it. By focusing and thinking about what it means to tell stories in judgments, it enhances our understanding of what's going on in the cases, but also of what's at stake. It's very easy to present tensions in cases as between conservative and more progressive views of something, and I use that not in the political sense, but in the sense of being in favour of change or against it. But actually, any legal argument requires a considerable amount of effort, of imagination. But this narrative coherence is crucial to persuading our audience. If it doesn't fit, if it doesn't make sense to us in a broad sense, we're not going to succeed in persuading whichever audience we're particularly aiming at. So, as I mentioned, I want to pick just two areas of the law. I picked them partly because I teach the law of trust and I teach the law of tort, so I'm interested in both of these areas. Also, as it happens in the last couple of years, these are two areas that both of the courts I'm thinking about have considered. And in addition, several justices of the New Zealand Supreme Court have written extracurrially about these issues. So I thought it was interesting because, although I'm focusing on judgments today, extracurrial speeches are also a valuable way in which we can shape institutional narratives and perceptions of the courts. So, I don't want to do lots and lots of charity law, but in order for something to be a charity, as a matter of law, it must be for a purpose that the law recognises as counting as charitable, the advancement of education, for example, and it must be for the public benefit. Now, exactly how that works out and what it means varies a little bit by jurisdiction, and we'll see the different stances taken by our respective courts in a moment. But just to illustrate this case, I'm going to start with the UK Supreme Court decision in Nuffield Health in a moment. Another key feature of a good story is, do you get your audience from the outset? What's your opening line like? And we can all think of some famous ones. I'm not being cliche, so I'm not referring to Lord Denning today. But two of my favourites, particularly for members of the public, let's see if from the opening line we can tell which way these cases go. Attorney General and Blake, this is a case involving contract damages and whether the Crown, the Attorney General, could sue George Blake, a spy, for the profits of a book he wrote about how much of a spy he was. Lord Nichols began, "My lords, George Blake is a notorious self-confessed traitor." George Blake lost. And then a less significant case, but a case under the protection from harassment legislation in England, where Ferguson and British Gas concerned whether a company could be liable for harassment or not. Lord Justice Jacob began, "It is one of the glories of this country that every now and then one of its citizens is prepared to take a stand against the big battalions of government or industry. Such a person is Lisa Ferguson," the claimant in this case. Lisa Ferguson won. So, it matters how we start our judgments, and if there are any doubts about this, just to show you the Supreme Court decision in Nuffield Health, which I'll tell you the facts about in a moment, here's how Lord Briggs and Lord Sales begin. Section 43.5 of 6A of the Local Government Finance Act provides for a mandatory 80% relief for business. Okay. They had me at section 43.5. Now, this might seem like a boring case, but I'm not suggesting they did this deliberately, but the judgment is actually quite boring and quite technocratic. And in doing that, they take some of the heat out of the controversy in the case. The case in Nuffield Health concerned a gym operated by Nuffield Health, which is a charity generally as an organisation in the UK for the advancement of health. They do a range of fitness activities, but they also have some gyms that you have to pay for. And at the time, the cheapest monthly membership was £71 if you got a deal, £80 otherwise. As you can see, we've just missed the deal to join by July the 31st, unfortunately. It's gone up a bit. There were some free facilities, but really only just to come in and have a look around. Right? So the problem in Nuffield Health was on this particular site, the fees charged by the charity were such as to exclude the poor. Right? I'm so sorry. It's about $150 a month if it's £80. So that's a lot, right? And that excludes the poor. Now, in England, the leading case law on the question of when charities can in principle charge at all for their services, which of course they can, has been in the context of fee-paying schools, private schools. The question was whether or how that line of cases apply to this different situation and the ludicrously exorbitant fees being charged by the gym, while still claiming that they should be entitled to business rates relief on the charity side. So, Lord Briggs and Lord Sales conclude that the charity was entitled to claim relief for this particular site in South London, notwithstanding the very high fee. And to do this, they trace, in a really engaging, not boring way, the history of two venerable bodies of English law, they say. They take us back to 1601 when, coincidentally, both statutes, original statutes laid this down. And they say it's worth outlining the history of development of both these streams of law because it sheds some useful light on the question of construction of legislation in its present-day form. Now, essentially, what the court concludes is that because Nuffield Health is registered as a charity, we have to accept that for the purposes of the particular site. And we have to accept that even though this is such as to exclude the poor at this particular site, because it's not true nationally and not true in every context. And crucially, they were delivering the purposes which are charitable at the particular site. So there are other cases involving offices or residence for workers of the charity which the court distinguishes. So it by no means follows that a purpose which serves both the rich and poor only satisfies the public benefit requirement, this separate requirement for a charity, so as to be charitable in the benefit which it provides to the poor members of its beneficial class. On the contrary, the scope is satisfied by reference to the whole section of the public, and some people are benefiting a lot from this charity providing its services. And then crucially, even if this may perhaps not accord with the perception of every modern thinking person untrained in charity law, this is true both as a matter of logic and authority. I've studied a lot of Supreme Court judgments, and I think that's the biggest understatement I can remember. But crucially, the narrative here is that this all fits the great arc of history. It's a coherent application of a different line of cases which have been differently controversial, but at the intersection of two fascinating areas of council tax and charity law. By going back to 1601, we reach a conclusion that this is all resolvable in favour of the charity. Now, to compare the New Zealand context, I'm going to focus on a case called Family First, again a very recent one, but before we do that, I just need to mention a predecessor case of Greenpeace. So this concerned Greenpeace in New Zealand, and importantly, the case itself in the Supreme Court didn't resolve whether it was a charity. That was remitted back to the lower courts, but it dealt with a point where there is now divergence between New Zealand and English law, as you can read about in the forthcoming edition of Hanbury and Martin, Modern Equity, out in all good bookshops from September. An important point of principle in English law and previously potentially in other common law jurisdictions was whether political purposes could be charitable. And what we mean in this context by political is whether the essence of the purpose requires a change in the law or potentially government policy. And the thinking behind this previous blanket rule was that it's invidious for the court to be deciding whether the law should change. Now, the challenge there is that, of course, lots of charities do campaigning work, raising awareness, trying to shape and influence policy. So can we, in modern times particularly with greater prevalence of advocacy organisations and so on, can we maintain that hard and fast distinction? In the New Zealand Supreme Court, in Greenpeace, it was held that this was no longer a automatic disqualification. So charitable and political purposes are not mutually exclusive if the political purpose is itself charitable because of the public benefit within the sense the law requires as charitable. A political purpose exclusion is not necessary. So the conclusion of the court here, the story we're telling, is that we don't need this hard and fast distinction because we have other ways of assessing whether it's problematic. So that was the line drawn in Greenpeace, obviously in the context of an environmental charity. Weirdly, they don't list the Supreme Court decision in their list of Greenpeace victories on the website yet. Okay, so Family First. I realise this might look like I've drawn this myself, but this is actually a cartoon on Family First website. Family First calls itself the Family Watchdog. This is an organisation that advocates for what would be what they call traditional, or might be called conservative with at least a small c, family values. And it was registered as a charity. Question for the court in the Family First decision was whether it should still be registered as a charity because it had been deregistered and they sought to challenge it. Now, in England, the campaigns that the charity engaged in related to euthanasia, abortion, equal marriage, for example. The English rule still applies to political purposes, so it wouldn't be eligible, or at least for the full suite of its purposes. But of course, in New Zealand, there's no longer this hard and fast rule, so the court has to consider how to make sense of whether this could be a charity. And there are two judgments here, a joint judgment to which several of the justices have signed up to, given by Justice O'Regan, which we'll start with, and then a concurring judgment by Justice Williams. And interestingly, there is a second distinction, a second hard and fast rule that we need to consider here. Family First argued that they could be charitable under two separate heads of charity, as we call it. One, advancement of education. Two, other purposes. lawyers always need a miscellaneous category. And in the context of education, there is a distinction between education and propaganda. So political propaganda masquerading as education cannot count. And that remains the case in England and in New Zealand. But there was a question for the court whether the removal of one hard and fast rule, the political purpose exception generally, also affected the political propaganda question. And the court held that it didn't, that there are independent reasons for maintaining wariness around the idea of propaganda because it doesn't provide the public benefit that comes from education. And the solution in Family First was that it wasn't entitled to charitable protection because its purposes were not merely ancillary to achieving a general charitable purpose. Rather, its purposes were the advocacy on freestanding issues of political controversy, which is not possible for the courts to consider as a matter of charitable law, because the court still doesn't have the means to judge the public benefit of a particular issue that will usually count against it. So this is not a hard and fast distinction, but it's applying the guidance in Greenpeace to the facts of the particular case. And crucially, the court is at pains to say this applies to both sides of any political debate. Right? Only one side of the political debate is before the court, right? But the court is emphasizing that they're not picking sides and saying one side is charitable, one side isn't. Of course, there is an argument that in the English context, this hard and fast rule, denying political purposes, is biased in one sense, in that whatever the law currently is, benefits. Right? Because if it's maintaining the current law, we haven't necessarily got the challenge of the courts being unable to judge, right? Because the courts just have to stick with what the law is because they can't judge whether a change would be beneficial. Now, what's interesting about Justice Williams's argument, in his judgment, the narrative, the story he tells is going back in history, but in a cooler way than the UK Supreme Court did in Nuffield Health, to think about what is the intellectual rationale. What is the rationale for charity law, not just in what term of Parliament was some legislation passed? How has the law developed? Why do we have charitable law? And referring to the process of evolving delineation through decisions over time. This is a narrative about narrative. And emphasizing the flexibility, the quest for nuance, which we all are after. And Justice Williams argues that charitable principles are about selflessness rather than being self-regarding. So an advocacy group, in principle, could promote a cause in a way that is charitable, even if they come down on one side of a debate, because that's what arguments are about, of course. But the question is, are you being self-referential or selfless? Are you engaging in debate? And as Justice Williams argues, it can contribute to social cohesion and the empowerment of individuals, while also respecting the communicator's right to their point of view. That's a narrative about narrative. I realise we're getting a bit meta here. But this is also crucial to resolving the decision on the facts. And because the nature of Family First advocacy, and the court had to read through all of the documents, all of the various brochures about particular issues, the conclusion is that Family First is not entitled to the protection. And Justice Costa and Justice Glazebrook have both written in this space. And I think what is interesting to highlight is when we're telling a story about this area of the law, what is our paradigm case? It might be the one before the court, which could be environmental charities, which you might think are heroic or might think go too far. It could be conservative family organisations. Or we can look at history. So the Conservative Party in England failed to establish itself as a charity. That's pretty clear as a case. But of course, William Wilberforce's Anti-Slavery Society, which both Justice Glazebrook and Justice Koch have cited, that undertook inherently political work, but patently for the general public benefit. But if our paradigm is a cause with which we think, with historical hindsight, was right, we're more likely to favour development of the law that captures that. Whereas if we start with a cause we're a bit less happy about, we might be more in favour of hard and fast rules. And my former colleague at Birmingham, who's now at Auckland, expert on charity law, Dr. Jane Calderwood-Norton, has made this point. and this is where I want to link it back to the idea of institutional narratives, even though it's charity law, which is about who has to pay tax on stuff a lot of the time, without recourse to the bright line rule, this is talking in the wake of Greenpeace, of the political purpose doctrine, decision makers, that's courts and charity regulators, must assess the public benefit of controversial organisations engaged in law reform advocacy. This poses challenges for institutional competence and constitutional legitimacy. So the advantage of a bright line rule is that the courts stay out of these questions. But that's equally problematic if we think the law does need to change. So the narrative here is about the development of the law, the arc of charity, what's the point of it all. But this also feeds into what are we expecting of our court as an institution and the implications of a legal change in one case for future regulation. So that's the charity pair of cases. The next pair of cases I want to deal with are about developing the law of tort. And they're in different areas, but they have in common that they're challenges that reach the respective Supreme Court of the relevant jurisdiction at what we call the strikeout stage. And this is a procedural question where if someone sues you, you can apply to the court to say, even taking their case at its best, even if they prove everything here, there's still a problem with their claim, they can't succeed, right? Because there's an element missing from the cause of action, for example. So rather than use up court's time, rather than people have to deal with claims that will inevitably fail, you can say to the court, take them at their word, say that all of these things happened, that you find in their favour all of the facts that haven't yet been proven. Nonetheless, I still win, so we will strike out the claim. And that is a point to remember throughout both of these cases, because it doesn't mean if a claimant wins when it comes to a strikeout that they win at the end of the story. All we're saying is that they get to tell their story in court. And what I want to argue is that each of these cases really matters as an example of the narrative of legal development. It also really matters to the parties involved. And it really matters for our understanding of how developments in private law can inform our understanding of the court's role as an institution. So to keep things balanced, I'm going to begin with the New Zealand court this time. And this is the Supreme Court decision in Smith and Fonterra. I've taken this photo of the relevant land from the Office of the Maori Trustee website, so thank you to them. This is a claim in a number of torts, what we call the tort of negligence, a failure to take reasonable care, tort of public nuisance, being annoying to lots of people, and that's not technical, and interestingly, an attempt to have just a new tort of systemic damage to the climate. So those are the three claims that Mr. Smith wanted to bring. Mr. Smith was a Ngāpuhi Ngāti Kao elder, and this land is in Northland. And he claimed an array of rights and connections to the land, both custom and community. And he wanted to sue a number of New Zealand companies who were involved in industries that generated greenhouse gases and contributed to climate change. And the argument was that this should be recognised in the common law of tort. Now, the Supreme Court had to wade its way through international obligations on New Zealand, a web of environmental regulatory statutes, and consider whether in principle these claims could be made. Because there are a number of potential problems with bringing the claim. Particularly, the common law is pretty reluctant to recognise new forms of damage. And there's a question as to whether we can conceive, as a matter of common law, of the damage that Mr. Smith is complaining about. There are also real problems in environmental contexts of causation. If you're simply saying you have engaged in a business that's generally added to greenhouse gases, and that has had an impact because of potential rise in sea levels, soil erosion, and so on, is that enough of a link of responsibility? Clearly in, we might say in a moral sense or a political sense, but can the law recognise this? And Mr. Smith recognised that, but he wanted to bring his claim. And he also argued that the common law here should be informed by Tikanga understandings. He didn't argue that there were any direct obligations owed, but argued that the common law should be willing to consider when deciding whether to develop, the court should look at these obligations. And Justice Williams and Koss, trust me, this is not the most awkward talk I've given in front of judges. as the heroic judges said in the Smith case, what is interesting here is that there are two narratives about what law's engaged here. One is the development of principles of the law of tort, the substantive case that we're going to get to if we go to trial, but also when should you strike out a claim? When should a defendant be able to say there is no chance of success here? Similarly, claimants can apply for summary judgment if they say there's no chance the defendant could win. So here we see the court frames it as the application of orthodox, long-settled principles governing strikeout, meaning that this should be allowed to proceed to trial. That's not commenting on whether it's going to succeed ultimately. But this is a framing of saying, hey, this all makes total sense. I'm not saying this is wrong. But this is saying long-settled principles, even though it's a novel claim that you're trying to bring in a number of different ways. So we start off from this idea of, well, sure, it sounds like it would be good to let them bring the claim. And then we also see a narrative about the potential for the common law to develop. And the court is careful not to prejudge the case, not to require the courts below to say that Mr. Smith will necessarily succeed, because it may well indeed be beyond the capacity of the common law to resolve climate change, but we're not convinced currently it's incapable of doing so. I think it's fair to say in England this would be struck out. That's just because our judges are harsher. But again, this narrative about how the law can develop. I realise the Vice Chancellor kindly mentioned my Twitter feed. There's a bit of meme on Twitter about Vice President Harris, who is now the nominee, having a trope that she often says in speeches, which I'm going to quote now because I think it applies here. But she said it many, many times in speeches, and when you clip them all together, it sounds insincere. But she talks about having regard to what could be unburdened by what has been. And she does that hand action every time, so it comes through. Here, this is a narrative about what the law could be partly burdened by what has been. So the common law has not previously grappled with the crisis all embracing its climate change, but we have dealt with the Industrial Revolution. We invoke Donoghue and Stevenson, everyone's favourite case for developing the law. And this matters because, in the context, at least in England, I won't prejudge the New Zealand situation. Tort lawyers are very conservative and traditional. Environmental lawyers are hip and happening and really want to develop the law all the time. This framing upsets that. It's a different narrative. It's saying it's clearly not beyond the capacity of tort law to respond. Yes, there need to be principled limits and have regard to it. And the final point there I think is important in paragraph 156. One argument for the defendants was if the law's to develop here, it's for the legislature, not for the courts. Well, what the justices point out here is that, well, actually the history of common law development as a whole is that if the courts get it wrong, the legislature can act. But it's a counsel of inaction to say we should always leave it to the legislature, we can't act, we can't develop the law. And this is presented as a coherent historical narrative. And then an important dimension in the Smith case is the potential for Tanga to inform the claims here. Importantly, the court only finds it necessary to focus on the public nuisance claim. It's enough for one claim to proceed because there's a lot of interconnected issues here. We might say that how it plays out will vary, because whether to develop existing principles of an existing recognised tort might be one thing, whether to recognise as a matter of common law a wholly new tort, even if it raises similar issues of causation and so on, might be thought to be distinct. But, as it was, all three claims are in principle allowed to proceed. And again, I mentioned this is an area that various justices have written on here. And I think it's fair to say again that the extracurrial observations of several justices of the court in this area have been influential, but also have said more than I think UK judges would, where there's a different tradition. But the Chief Justice in a fascinating lecture, Renovating the House of Law, points to the challenge of climate change and says there's a growing demand, particularly amongst the young, for environmental justice to the extent that our institutions, including our courts, are seen to fail to deliver that justice, they may lose public confidence and thus legitimacy. Institutional narrative, where it's not just about, it matters to Mr. Smith whether he can claim, it matters to his community, matters to all of us, whether the law can respond to climate change, but also whether the law develops in this area or not feeds into what we think about the Supreme Court. And that can go to the court's legitimacy. An institutional narrative that has regard to the standing of the court amongst the wider public shapes that narrative further. So the final substantive case before a couple of conclusions. Paul and Royal Wolverhampton NHS Trust, a recent UK Supreme Court decision involving psychiatric harm. I mentioned that factual narratives matter. As I've said, the stakes for Mr. Smith in his case were very, very high. Paul and Royal Wolverhampton NHS Trust is a case about when family members can recover if they suffer psychiatric harm after the death of a loved one. And each of the cases is ineffably sad, but I do want to speak to, just briefly, without wanting to distress anybody, the facts, because the factual narrative matters. It was 3 conjoined appeals brought to the court. In the case of Paul, 2 daughters saw their father collapse with a heart attack. Several months before, he had been to the Royal Wolverhampton Hospital complaining of chest pain, but he'd been discharged without being subject to the relevant scan that would have identified the heart problem. That was accepted in principle as being negligent, but the hospital argued that because they didn't witness his death in an accident, the daughters, when they later developed post-traumatic stress disorder, couldn't sue. Polmere involved the tragic death of Esme Polmere, a girl in primary school. She was 6 when initially seen by doctors. She had been having trouble breathing, and they went to the doctors, but the doctor just thought it was a sign of exertion. But she actually had an underlying health condition, and she went on a school trip to the beach. Her father had dropped her off, but agreed to come back if she wasn't feeling too well. He did come back and found her unconscious, with the teachers trying to resuscitate her. The father tried to resuscitate her as well, to no avail. Her lips were blue. Her mother later came on the scene, and they suffered post-traumatic stress disorder after her death. Again, because it wasn't a single accident that they witnessed, it was instead negligence sometime before, and then the tragic event afterwards, it was argued that there was no duty of care owed to the parents. And finally, in the case of Purchase, this is a mother who came back to find her daughter unconscious, again having not had the correct disease diagnosed of pneumonia. The mother tried to resuscitate her, but couldn't do so. And after the paramedics had been called, her mother found a voicemail on her phone that was her daughter struggling to breathe, and understandably suffered psychiatric harm as a result of this. So these are utterly tragic cases. The facts matter, the narrative matters. The Supreme Court, by a majority, this is the only case where there was a dissent of the ones I'm talking about tonight, held that none of these families could claim. And the lead judgment is, I think, extraordinary, but it begins, we all die, and when we do, the fact or manner of our deaths may cause harm to other people. Death may have a variety of consequences. So the judges do later on express sympathy and say nothing here is intended to diminish the suffering that they've encountered. You just can't claim for it in the law of tort. But importantly, for our narrative point, the facts are not of that much interest in this judgment as far as the majority is concerned. The framing is that whether people can claim at all for psychiatric harm when somebody else has died or suffered injury, which is a line of accident-related cases, is itself an exception. So the common law essentially does not recognize one person as having any legally compensable interest in the physical well-being of another. So this is an exception. And there are cases that we have to understand, says the Supreme Court. But the claimants argued the way to make sense of this was to say we need to slightly broaden the category of people who can sue. That's a way to make it coherent rather than privileging people who happen to have been injured, seen their loved one injured or die in an accident rather than after a case of medical negligence. But this framing, right, this narrative, about what the law already is, but also how it should be reconciled. How do we deal with what is thought to be inconsistencies? Do we broaden the category, or do we take away the right to sue from more people, which is what the majority decide? But the framing matters, right? The narrative here is that this is all an exception, right? They're lucky to be included at all, and we need to rationalize the exception here. And there's also a bit of an appeal to the man or woman in the street. Most people would, we think, accept that if a line is going to be drawn between cases where illness consequent on bereavement is compensable and cases where it's not, distinguishing between claimants who suffered the ordeal of actually witnessing the accident in which a close relative was killed and those who did not is an intelligible place to draw it. That's not an empirical claim, it's an appeal to the mythical man or woman in the street. I'm not sure if we call up the man or woman in the street and explain the factual narrative of the cases in the way that I did, that the judges can be so secure in that conclusion. And as I say, they don't mean in any way to minimize this, but they don't think the ordinary person would expect. Now, I'll come back to Lord Borrin's dissent in a moment. Importantly, the majority judgment is also radical. It removes a couple of barriers to claims that had developed in certain contexts, so whether the event had to be sufficiently horrifying, which is a grotesque question to ask when your loved one has died. They remove a requirement that was thought that it had to be a sudden shock. So they do change some bits of the law. But this is also presented as following inexorably from fundamental principle. But that in and of itself is a narrative justifying what is a change in the law, removing some categories where before this case you could sue and now you can't, as well as declining insofar as an extension was thought to be required. Lord Barrow's dissents and takes the opposite view. Always a sign of where we're going when a judge says, I've read with admiration the judgments of Lord Leggett and Lady Rose. And Lord Rose puts it in fairly strong terms, but it's a completely different narrative. How do we make sense of the cases that seem to allow recovery in some of these areas? We should rationalise it by broadening the category, by taking the opportunity here as the Supreme Court to develop the law, rather than turning the clock back and overruling some authority. Even if the better view, Lord Barrows presents more than one narrative to reach his conclusion, in my view, this would be a justified incremental step. There's a battle for who's being the most incremental here. Incremental step that falls well within the traditional judicial role, institutional questions as well, in correcting errors and keeping the common law up to date. These appeals present a rare opportunity for this court to move the law forward by traditional incremental development to a more satisfactory position that is closer to what is arguably the only truly principled solution. Right? Both the majority and minority think they're doing the same thing while reaching diametrically opposed results. But it's not just about the outcome in these cases or what the law should be. It's a wider narrative of what the court thinks it should be doing when it comes to developing the law, the institutional narrative as well as the narrative about legal development. So, just to conclude, I took this morning on a run. The Chief Justice has hinted at this institutional question. The court sees itself as having an institutional role that is not exhausted by the release of its judgment, but entails the provision by a variety of means of information about the law, its processes, and about the court. Our court system is a vital part of the social infrastructure of our society, but the role of the courts and of the judiciary is little understood beyond the walls of law schools and court buildings. Now, my colleague Professor Knight has written on aspects of extracurricular engagement, and I've got some interest in that as well. What I've tried to argue here is that within the judgments, there's more than one source of information about the institutional role of the courts. And yes, communication around them is great, and all of this is building up our picture. So if you don't follow the UK Supreme Court and the courts of New Zealand on Twitter, now's your chance. But all of this extracurricular, beyond the courtroom engagement feeds into the institutional narrative as well. But regardless of how many Instagram videos there are or annual reports, if the substance of the judgments themselves of the courts don't build up this giant picture of the institutional role, the effective actors in our constitution, of the institution of our Supreme Courts, there's a problem. So just a final couple of thoughts. When it comes to narratives of legal development, I think it's worth thinking about whatever your favorite video service is, whether it's Prime Video, Netflix, right? Each case could be seen as a single episode. But then there are also, as well as the story of that particular episode, there are narrative arcs, right, that run throughout an entire season and also over the course of an entire series. One of the joys of thinking about the common law in this way is that we can get a deeper understanding. We can see more things that are going on, follow more storylines. And the great thing about the common law is, unlike your favorite Netflix or Prime Video show, it can't be cancelled. So to reflect to... I've spoken a lot about narrative institutions and also our imagination. How do we think creatively about the law? How do you imagine what could be as well as what has been? And the American academic J.B. White in the 1970s published an extraordinary course book called The Legal Imagination that blends literary criticism and the law. And he makes this point, particularly for students and members of the public, to conclude. The activities of the lawyer's life are imaginative in yet a further way that I've not yet mentioned. They include the process of self-imagination. For as you work through your life as a lawyer, you work out an identity for yourself. You define a mind and a character very much as the historian or poet or novelist might be said to do. It's also what our collective and collegial judges on our final courts of appeal are doing for themselves and for the courts. And for the rest, it's our story to tell. Thank you very much.